Hey friends, criminal defense attorney Ryan Pacyga, and today I'm going to talk to you about getting a lower sentence in federal court, right? So, federal court is notorious for having really high sentencing guidelines and often very harsh sentences, including mandatory minimums sometimes of 10, 15, 20 years, or sometimes even life. And so, federal court is a harsh place, right? And sometimes, let's face it, there's a case where the evidence is so strong that there's no way a defendant is going to get out of it. The case isn't going to get thrown out. They're not going to win at trial. It is just cut clear that there's so much evidence that their best option is to plead guilty. Because if they go to trial and lose, they're going to lose what's called the 3-point acceptance of responsibility and oftentimes get a harsher sentence from the judge. Not always, but often. And they kind of call that the trial tax, right? So in some situations, it is your best option to get the lowest sentence possible by pleading guilty in a case isn't going to get thrown out or you're not going to win a trial. So what do you do in that situation, though? So in federal court, they use the federal sentencing guidelines, and those are calculated, and it's sometimes complicated. But at any rate, eventually we arrive at a calculation, and the judge arrives at a calculation, and probation arrives at it. And then the judge hears arguments from lawyers about whether these guideline calculations are correct or whether they should be lowered and for what reasons, or even sometimes increased and the like, right? So the first thing a lawyer can do if it becomes a case about sentencing advocacy to get the lowest sentence possible is, number one, try to avoid a mandatory minimum sentence for a client. There's a couple ways to do that. Not every case can avoid mandatory minimums, but there are some ways. I was just able to do it today for a client, number one. Number two, if you can avoid the mandatory minimum guideline sentence, then another thing you want to do is lower the guideline range as much as possible. Sometimes that means we have disagreements in court, the prosecution and the defense, about whether there should be adjustments in the guidelines. For example, in a conspiracy case, I can argue for what's called a minor role adjustment and lower the guidelines for a client that way. The government will often oppose that and say that the guidelines should not receive an adjustment for that, or sometimes they go for an upward adjustment on people, right? So you can argue about those things and try to manipulate in a legal way the guidelines to get the lowest guideline range possible for the judge to consider. So once these guidelines are arrived at, assuming there's no mandatory minimum, the judge looks at a range of months on this sentencing table that's used. And in a case like today I had, the range of months was 108 to 135 months. That range is kind of suggested by the sentencing guidelines as being an appropriate sentence under the law in this particular case, okay? And the prosecutor asked the judge to sentence within a guideline range. I was able to convince the judge that in this case the guidelines ought to be lower because in methamphetamine cases, it used to be that really pure meth was sentenced higher, it still is, but that only the people that were close to the source had access to the really pure meth, and so they were considered to be more criminally responsible if they were close to, for example, the cartel or something like that. Well, nowadays, most of the meth coming into the United States, virtually all of it, is very, very pure, and so the analysis about that has changed, and more judges are agreeing with the argument that says, wait a minute, almost all the meth nowadays is pure, not just a fraction of it, and for that reason it would be unfair to treat the law that way on a defendant. And the judge agreed with that, so he agreed to lower the guidelines some to that. And I think the guideline range came down to about 75 or 85 months in that situation. Still a hefty sentence that he was looking at. Well, the prosecutor argued for a sentence within the guideline range, whether it was a 108 to 135 or about the 85-month range. And I argued what are called the 3553 factors to the judge. Those are things that a lawyer can argue about that tells the whole story about the defendant and not just the story about the case. So in this case, my client's heavy addiction that he suffered from years, some good things he's done in his life, how well he's done on what's called pretrial release and staying sober on pretrial release and not reoffending and those sorts of things, and a bunch of other good things that he's done in this case, right? Ultimately, today I was able to convince the judge, despite a prosecutor's position of much more time, to give the client 46 months. Now, 46 months in prison is no small bit, right? But when you're starting off facing 108 to 135 as the recommended sentence, that's a major difference down. The client was very happy with that sentence because he knew this was a, you know, tons and tons of methamphetamine kind of situation here in this conspiracy. So it was a very, very large case going on for many years in a trafficking situation. So it was a serious one. At any rate, having a lawyer that knows and understands the guidelines and how to lower them or advocate for them being lowered, number one, and then even despite whatever the guideline range is, having a judge vary downward from that. It's called a downward variance, and give a sentence that's lower than this guideline range can become really important because, you know, for this particular client, for example, he's looking at, we saved somewhere in the neighborhood of, you know, 4 to 7 years of additional prison time that he would have had in this case. And I've worked with them for over a year on it now. And I'm really happy with the result today, despite it being that kind of time, because again, everybody wishes their case could be thrown out. We want that for clients if their rights have been violated. People wish that they could go to trial and win, but that's not always the situation. Let's be real. In some cases, the evidence is so strong that you're best off pleading guilty, and then it becomes what kind of sentence is fair, what's the best sentence you can get under the circumstances, and that can be where the value is in some cases for having a lawyer that knows what they're doing and is committed to doing that. Because while 46 months is a decent sentence, still, it's a hell of a lot better than 8 or 9 years, isn't it? And I wanted to educate you about that today. Those are called the 3553 factors in federal court, and lawyers can argue for a downward variance based on the history and characteristics of the defendant. If you have any questions about federal criminal cases, I'm attorney Ryan Pacyga. You can find me at arrestedmn.com or call me at 612-339-5844. Roam free.